My name is Frank Acuna. I'm a partner at Acuna Wrigley & Klein. We are a law firm in Walnut Creek. Thank you all for coming out to see us this evening. We really do appreciate it. Want to introduce my cohorts, my partners in crime, Tim Krish of Mays & Associates, Scott Hayden at Hayden Financial. You want to just take a couple moments and tell people who you are and what we're doing and who are the people from your office and all that other good stuff? Tim?
Thank you, Frank. And I parrot what Frank said. Thank you all for being here this evening. My name is Tim Krish. I'm a partner at Mays & Associates in Pleasant Hill. We are a, I guess for lack of a better term, full-service accounting practice specializing in a number of areas, but certainly tax and estate planning, as well as municipal and nonprofit audit. We're a group of about 45 individuals, and just to let those of you who don't know, Frank, Scott, and I have been working together for, well, Frank and I over 20 years now, and Scott probably 10 to 15 years now. So, Scott?
Thank you and welcome this evening. My name is Scott Hayden, and my business is Hayden Financial and Insurance Solutions. With me is my office manager, Rosalind Christensen. She's standing there in the back. And I've been in business 27 years. Our business has two sides of it. We're located in Danville by the old oak tree, if you know where that is. We have a planning side. Most of our time in planning is business and estate planning. I'm part of a select group in Dallas, Texas called the Nautilus Group. There are 200 of us in the country. And then on the other side of the business, we have the product side. So when we need liquidity and funding, we have the insurance, which I'm the liquidity guy from the attorney and the tax guy today. So welcome. And if you have any questions, please feel free to, ask them during the session or afterwards. And in the back, we have brochures that explain our process and everything that you're more than welcome to take. Thank you very much for coming.
And then to explain who I am, I'm Frank Acuna. I am an attorney. I'm a state bar certified specialist in estate planning, probate, and trust administration. And our firm really focuses on family wealth transfers, whether it's estate planning or doing family limited partnerships for families who have real estate, or all the other types of things that go into a good estate plan. I'm joined today by my office manager, Linnell Glissman, who is the person who really put this thing together and has been running and gunning all week. My assistant, Heather Caraher, back there, she is the person who runs my calendar and makes sure that I get everywhere I'm supposed to be on time. And if you ever need anything from me, you call Heather and she tracks me down and hurts me until I get back to you. My partner, Tracy Wrigley. Tracy does probate, trust, and conservatorship work in our firm. And my partner, Jackie Klein. Jackie is an estate planner and also does corporate work and the kind of business association work that you need to do to make this all work together. We're going to spend about an hour and a half together talking about family wealth transfers for families that have real estate investments. And think of this as free time with an attorney, an accountant, and a financial professional. So you get to ask anything that you want. So I'm going to start just right now with, what are the burning questions that you have that you really want answered in the next hour and a half? Or are you going to let a lawyer just keep talking and fill in the room with hot air? Yes, sir, in the back. So properties that are in a trust, how do you organize them for what we call asset protection planning, to make sure that creditors can't get the properties, or if something happens to properties, creditors can't get you? Other questions that you want answered tonight?
Identify the taxes that are applicable to various scenarios.
Taxes applicable to various scenarios. Fortunately, we have the tax expert. Other questions? Yes, sir.
Stepped-up basis and possibility of changing that law.
Basis step-ups and whether or not that law will ever be changed. Okay, we can talk about that. Other things that you want to talk about? Yes, sir.
Exit strategy on rental property.
Exit strategy on rental properties. How to get away from toilets, tenants, and trash. The three terrible T's.
You said it better than I did.
Yep. Oh, I do have one on toilets, tenants, and trash. Yeah. Other things that you want to talk about? Yes, ma'am. Gift tax and estate tax, and when is the right time to give property away? See, one of the best exit strategies, stick your kids with it. But when do you do it so that you can save the most on taxes? So we'll talk about that. Other things. So properties that are jointly held by a number of families, we're going to show you how to set it up so that it's a little bit better to manage and then better to make the decisions on getting in and out. If there's any question here, if anybody here would like a separate seminar on 1031 exchanges and how to save on capital gains tax when you get out of properties, you might want to just jot a note down on the response cards. On your chairs, you should have gotten a card that looks like this. And here you can either ask for a consultation with Tim, Scott, or me, or you can just jot, boy, I'd really like a seminar on 1031 exchange, or I'd really like a seminar on IRA planning and how to kill the income tax on IRAs. That would be a great place to jot that down and then make sure one of us gets it. But let's launch in. I think we can get most of those questions answered today. Any preliminary comments? You guys want to just jump on in? Racehorses in the gate. Here we go. Okay, this is the commercial message. Every family needs a team of professionals. No one professional can do it all. And I'll be really, really honest with you. In some ways, the attorney is the least important in this mix. The most important, quite honestly, for most of us is the tax professional. We earn, we want to keep as much as possible so that we can invest.
And Frank, if I can interject here, one of the ways that we find we're most successful in working with clients is when all of us are with you at the exact same time. So we're helping you drill down to find out what it is you're really trying to accomplish. What is that goal you may or may not know about? And then all of us are hearing the same strategy, and we come up with the same solutions. Instead of us going to different advisors, getting different strategies, a lot of times it just doesn't come to place.
And then, even though we are three professionals here, we are not linked to each other. If you have a good attorney, great. Pick up a good tax professional, pick up a good financial professional, and all the other permutations. Once we've got the tax professional in place, the financial professional, someone who can not only help with protecting your assets with insurance, but also with investing wisely. And then finally, the attorney's job is to come behind what these other two guys have done and really make it work in terms of handing it off to the next generation. Okay, here's what's going on in the current estate tax law. Tim, did you want to take this one?
Sure, thank you. And I know somebody already elevated this question, but one of the current keys, based on actual law in place as of this evening, is the fact that the first $5 million of one's estate can be transferred tax-free. That is indexed for inflation, and if we were to pass away this year, it would be a little bit better than $5.3 million that would be excluded from the estate tax. Whether or not that's permanent, I wouldn't take that bet. We're approaching another election year, and Lord only knows what's going to happen. There's too much unrest worldwide, and the United States isn't a standalone like it used to be. So the environment weighs in on it, world unrest. As we've indicated here, Social Security and Medicare is a big question mark for what gets factored in. And then the oxymoron of the Affordable Care Act has to be paid for as well. So any one of these can be an impact to the existing state tax law. The final snippet here is whether or not real estate's the best investment. And based on the last 50 years of returns, at least within the state of California, real estate leads. The overall rate of return has been a little bit better than 13%.
Here's the thing. With all that going on, if you have investment real estate, if you have a family house, you'd have to do some sort of estate planning. Even if you don't have a tax problem, there's always probate. And probate is obscenely expensive in California and obscenely time-consuming. To probate an estate, we're taking in Contra Costa County now between 15 and 18 months. And the price of probating an estate, if you had $1 million estate, you apply these percentages and you realize that 4% to the attorney, 4% to the executor, 3% of the next 100,000. You add it up for $1 million estate, you're looking at a year and a half in probate court and total probate fees of $46,000. That's ridiculous. That's ridiculous. So at the very basics, before we even get into some of the more complex planning at the very basics. If you are invested in real estate, whether it's your home or investment property, we still have to think about a living trust. It's the very basic estate plan. One of the things we want to find out about also, if you are invested in real estate, what we're finding is estate tax may not be the big issue. It may not be the big problem. Real property tax reassessment, that's the big problem. Because your property tax assessment may be very, very small. Your rental property may have a real property tax assessment of only $500,000. Whereas in reality, when you die, we're worried that that's going to go up to $2 million. So properly planning, we might be able to avoid altogether a real property tax reassessment. We already talked about this. There's other risks with real estate. There's other risks with transferring wealth to the next generation. It's not just time consuming. Probate's not just public, and it's not just frustrating, but if you go to probate court, it's that whole thing of it being public. There's a little man in the probate court every day, and what he's doing is taking the information from all the probate petitions. He knows exactly who's going to inherit it, when they're going to inherit, how much they're going to inherit, and you got to know every marketer, every bottom feeder on God's good green earth is going to get in on that. So we want to avoid that and get into a living trust at the very basics. Then what we want to do, if you have significant real estate wealth, we want to plan so that your heirs don't lose it. Here's the statistic that's going to blow your mind. The average inheritance, no matter how large or how small, is blown through by the heirs in 30 months. 30, 2.5 years, it's gone. Do you have any more war stories? I mean, we've all seen it.
One of the institutes I work with, the Oshley Institute, they find that if your children aren't involved in your planning, the strategies you develop while you're working with your advisors, not only will they probably change advisors, but the whole strategy will change within 3 years. So the earlier you can bring in, if there's going to be generation shifting, if your children are going to be managing properties, or they're going to be working with you, or you're taking care of grandchildren on generation skipping, they should be part of the process if they're adults now and not receive something unexpected before. So they know who your advisors are. If they don't like them, bring it up to you now, not after the fact.
One of the other things that we see is that when we have fragmented families, sometimes it's a second marriage or a third marriage, kids from different families, or multiple children from the same two parents. We see a lot more fighting now going on, a lot more competition for those resources. And so what happens is that the poor kid who's chosen as the trustee now has to worry about his brother and sister coming after him. And now instead of just, gee, this is my brother and sister and we've always argued, now he's got this thing called fiduciary duty because he's the trustee. Fiduciary duty is what a trustee owes to all the beneficiaries. It is the highest standard in the law. If you're a fiduciary, if you're a trustee, and you make a decision that made perfect business sense when you made it, but it didn't turn out right, you can be on the hook for all the losses. And losses are sometimes measured as it just wasn't as good as the next investment. So fiduciary duty, being a trustee for years and years and years, for those who are thinking, gee, I don't want my kids to lose it in 30 months, I'm going to put it in trust and hold on to it for their entire lifetime, that can be a noose. And I'll tell you right now, I'm very sensitive to this noose because I come from a very, very large family. And I tell people that the 4 scariest words in the English language are, Frankie will do it. I'm the oldest son, the oldest grandson, and the only lawyer in the family, and the entire family says, Frankie will do it. Ah, not so good. The better alternative is a standard called ordinary business judgment. Ordinary business judgment. And here's where we start talking about how to deal with significant real estate assets. Instead of creating a trust where you're going to control and you're going to make sure that the kids keep it all together, create a business entity instead that will own the real estate. Create a family limited partnership or a limited liability company, and then anoint the child, anoint the grandchild who you think is the best manager to be the manager of the LLC or the president of the general partner of the limited partnership. Why? Because if you're a trustee, you have fiduciary duty, but if you're the manager of an LLC, you have what's called the ordinary business judgment standard. What that is instead of being able to look at what you did and say, oh, gee, you could have done better, no. If the decision about the property, if the decision about the business made sense at the time you made it with the facts that you had, that's it. You filled your duty. So now you can go ahead and say, Frankie, we want you to take care of this for your brothers, your sisters, your aunts, your uncles, your cousins. But instead of carrying that fiduciary duty with that big red circle on my back that looks like that nice department store down the street, the Target, or Target if you have daughters, instead of having that kind of fiduciary duty placed on you, now the standard is, did I exercise a business manager's ordinary judgment? Audrey. Correct. What we'll do is for families that have those real estate holdings, we create that separate entity. That separate entity is the actual owner of the real estate holdings or what have you. And then mom and dad, like shares of stock, they hold the shares of stock. They hold the limited partnership interest. They hold the LLC interest inside of their trust. So the trust is still involved. But now that child who's going to manage for his brothers or her sisters or her brothers or his sisters, whatever the different thing is, great. They're no longer held to that fiduciary standard. They're held to the standard that you would hold a business manager to. Still means they're responsible.
Frank,
not so liable.
Can I respond, Audrey? Audrey, I'm from a small little family in Ohio that had a farm from the early 1900s. My sister happens to be a real estate developer who knows everything back on the East Coast. After 6 years of selling a little farm, which all my parents had, we still don't talk because she knew more than I. And I wish I could have convinced my parents to put their small little plot of assets in some kind of entity so we would be able to eliminate all that discussion that we never had.
Let me just give you an example. Let's say that you have 2 kids, or let's say you have 3 kids. If 3 children inherit a piece of property and they're all placed on the deed because they've inherited it, any one of those children can get involved in a lawsuit, or any one of those children can file a lawsuit to force the sale of the property. It's called a partition action. However, we can create an LLC, a limited liability company, or an LP, a limited partnership, where no member, nobody who holds an interest, none of those kids can file a partition action. And we can create it in such a way that Tim can do some tax dirt to some of the creditors so that they wind up holding nothing but liability. It's kind of fun. We'll show you now with some case studies. Our planning challenge is use these higher gift limits while we still have them. We've got $5.34 million to play with. How long? We don't know. Let's use it while we got it, because as long as you do your planning based on those limits, it's locked in. And even if the law changes, they can't take away what you've already done. That's really cool. So we've got this golden opportunity here. Right now, it's not just $5.34 million when you die. It's $5.34 million that you can give away while you're still alive. So let's use it while we've got it. And let's also think about generation skipping. Tim, could you explain what generation skipping is?
I wish I could sum it up real quickly, but it can be much more complicated than the 2 words presented. The key is, if I as a grandparent wanted to essentially bypass my children and get it to the 2nd generation beyond them, it's just skipping that generation and completely legal. It's just that there's special filing that needs to be done with the IRS because they don't like you to skip one level of taxation. So it's just an additional reporting, but a lot of times we don't necessarily want to include all of our children or their spouses, etc., and there's reasons to skip a generation.
Let me give you just a what if. Can I create a trust where I let my kids have the income, but ultimately it's my grandkids who are going to receive the property?
Absolutely.
And that would qualify for that, being able to skip a whole generation of tax.
Correct.
Awesome stuff. Awesome stuff. Okay, let's take a look at some case studies. And this is where it gets kind of fun. Fred's been diagnosed with, well, this is not a fun situation. I apologize for that. But Fred's been diagnosed with end-stage pancreatic cancer. He has 3 months to live. By the way, the names have been changed, but these are all actual cases that 1, 2, or 3 of us are dealing with. He does not have a living trust, has not done any advanced estate planning. He has a $6.5 million estate, of which $5 million is in commercial real estate. Remember, how much could we give tax-free this year if he dies this year? 5.34. He's at $6.5 million, so he's got problems. He's got $1.16 million that's going to be taxable, and the tax on that is going to be $464,000. Or he's going to have probate fees, which are going to be humongous, which means his total, or it's not or, it's and, which means he's got a total loss in this estate potentially of $720,000. I'm going to throw it open. This is cool. I've got friends who are experts. Guys, what would you do?
Well, before I start jumping to solutions, one thing to remember is that if you don't care about what your heirs inherit, you don't have to do anything. Fred doesn't have the problem here. His kids do, or his estate does.
So what you would say is Fred should stick the kids with the estate planning bill?
At a minimum.
Case, Frank.
So what would you suggest when you're looking at this kind of estate?
Initially, or to begin with, would be a living trust, but then I would also take a look at being able to transfer the commercial property into a LLC or a limited partnership, family limited partnership. And in that process, there's a number of benefits. Fred retains control because he would be the general partner or the managing member of the LLC. There's a number of benefits, but the property, the commercial real estate could be transferred into an LLC. It can be, at that point in time, Fred can gift to his heirs 50% of that entity. And what happens when the children or the heirs have no real control in the entity, the IRS allows us to discount the transfer of those assets. So in our example here, the $5 million commercial property, the IRS is currently allowing a 35% discount of that amount, which is $1.7 million, I think, give or take.
Yeah, we'll go to the next thing.
Okay.
There's one other thing that you can do when you're creating this limited partnership or LLC. Tim's focusing on tax. I'm focusing on management. And one of the things that I'm focusing on here is an idea of a restrictive buy-sell agreement. What is that? That's an agreement that anybody who ever gets any piece of this action will have to sign. And what it says is that only the lineal descendants of Fred can own any part of this company, this limited partnership or this limited liability company. So does that mean that the in-laws and outlaws can inherit it? No. Does it mean that creditors can own a piece of the action? No. Can you provide income to my wife for life as long as my children get it? Yes, you can do that. But we're restricting not only the control that Tim's focusing on because of the percentages, but also the marketability. And that's where we get nobody. The IRS knows that nobody will spend 100 cents on the dollar for something that they can't control and something that they can't sell on the open market. And because of those two restrictions, that's where that discount comes in.
Frank, on that control section on the buy-sell agreement,
Yeah.
you said lineal descendants of Fred.
Mm-hmm.
Does that mean that it's immediately commingled as community property in the state of California?
No.
Or is that protected?
It's protected. Again, if only the lineal descendants can own it and the husband or the wife can't, if an in-law or an outlaw decides to file for divorce, your children, your grandchildren do not lose that investment. And here's a fun one. Let's say that a grandchild who owns part of the limited partnership gets in an auto accident and the people die and the insurance is horrible, and they have to file bankruptcy, and now the bankruptcy trustee says, well, he's got this asset. I want his part of the limited partnership. Can the bankruptcy trustee attach it? The answer is probably, but, Tim, there's a tax trick that Tim is the first person that I ever saw do it, and I just gone, oh, that's good.
I'm trying to remember what
This is on distributions, on the K1.
I'm drawing a blank on
Okay.
what we pulled off. Sorry.
What Tim did that I thought was just absolutely brilliant, and this goes back about 15, 20 years.
Oh, you expect me to remember that, huh?
Of course. Because we've used it since. Think of this. Let's say I'm a limited partner. I got into trouble. My creditors now have my limited partner share. What happens with a limited partnership, what happens with an LLC is at the end of the year, you have to report the taxes. And you give each limited partner a K-1 saying, here's your portion of the income. But here's the killer. The general partner or the manager of the LLC does not have to actually distribute that income. So Uncle Sam's going to come to that creditor and say, hey, I want my taxes. But we didn't give that creditor the money to pay those taxes. So do you think now that the creditor is going to be a little bit reasonable about settling and getting out of Dodge? Yeah. So we can sell that, we can buy that back from that creditor at a drastic deep dish discount that is nothing compared to what the value of that claim should have been. Tim was absolutely right. That $5 million would receive $1.75 million in reduction in value. It would only be valued as if it was $3.25 million in the estate. So what did we just do? We just reduced the total taxable estate to only $4.75 million. All right, pop quiz. How much can we give tax-free to our kids? 5.34. Do we now have a taxable estate? No. We just saved all of that tax that we were supposed to have paid. There's variations, but this is actually going on in our office right now, and the family has just saved on all the estate tax that would have otherwise been payable. Tim?
I was going to say that it saves a probate as well because there would have been a living trust structured. So going back a few slides, it would have been $720,000 in savings to the heirs.
Yep. And the cool thing is, while Fred is still with us and able to make decisions, he's chosen who the managers are going to be for the next generation. We've also protected this manager because they no longer have fiduciary liability. They now have ordinary business judgment. And we have a way for, in this family, there's 3 kids, we have a way for them to vote on who will be the next manager after that. So the grandchildren will be able to participate, and the great-grandchildren and the great-great-grandchildren. We're not going to lose this property because it's going to be sold or it's going to be lost to creditors or lost to divorces. This is now going to stay family heirloom property for generations. Let's give you another example. Betty and Barney, blended family, married for almost 60 years when Barney dies. This is an actual case. This is a case that Tracy in our office worked on. She was doing the trust administration after the first person passed away. They owned 30 properties, from single-family residences to duplexes and fourplexes to the crown jewel. It was an apartment building. And, of course, everybody wanted to get their hands on the apartment building. They had no children, so each wanted to give their half. Betty wanted to give her half to her brothers and sisters and then nieces and nephews. Barney wanted to do the same for his. Each of them named one of their brothers as co-trustees. And they actually got along pretty well. But they were concerned. What kind of liability am I carrying here? Betty's now in assisted living and is incompetent. The 2 trustees get along, but they're already getting pushback from the family members. Man, when you're a trustee and you're part of my family, you're supposed to be fighting for my rights, not doing what is right. So they're getting pushback already. And each of those family members wants to make sure that they get the family building and all the better properties. What's the solution here? And I'll probably take this one because this has less to do with tax and more to do with fiduciary liability and more to do with making sure that it all comes out equal.
It always has something to do with tax, though.
That's true. That's true. Dang. What the solution was here is, again, using an LLC, in this case, and creating a limited liability company that would hold all 30 properties. So we started with the family trust and 30 properties. And we had the survivor trust and the decedent trust. And you can see that if you have to squabble over which trust gets what property, problems. If you try to split it in half the apartment building over here, half the apartment building over there, you got more problems still. Any one of those heirs could go ahead and file a partition action. But by creating an LLC, now instead of properties going into the survivor's trust and the decedent trust, now what we have is just 50% of the company going into the survivor trust and 50% going into the decedent trust. We don't have to worry about, do I have the apartment building? Yeah, you got 50% of the apartment building. And because of the way that we structured the company, nobody has the right to force a partition sale of any of the properties. And nobody's creditors have the right really to come after this structure. We have ways such as the K1 method of pushing back and saying, no, you don't get it. So what have we just done? We've now created a family business that will carry forward into the next generations for 2 different families. And we've also created a restriction so that if one of them wants to cash out, great. They've got to sell to one of the other members of the limited liability company or one of the other limited partners. Is that cool or what? 30 properties now preserved. Yes, sir. Question is, can an LLC also include stocks, bonds, and IRAs? IRAs, no. IRAs, remember, are a retirement plan where they're supposed to be stapled onto a living, breathing human being so that someday, sometime, the government's going to get its income tax on it. But stocks, bonds, cash, real estate, yes, we can use them for those. We don't get as big a discount on cash or stocks and bonds because they're easily marketable. So we don't get the marketability discount. But we can put cash, some operating capital, or some stock as operating capital in the LLC or the LP as well. Okay? Yes, sir, in the back. The question is if you have 10 properties or if you have 30 properties in an LLC, can a creditor get all the properties? All the creditor is going to get is a percentage in the LLC. So we have a way, and we've already talked about one way, there's a bunch of other ways of making sure that that creditor gets very, very little and has to sell that interest because they're not a lineal descendant. So can they get all the properties? No. There's always, there's always the potential of a lawsuit. There's always the potential of a creditor. But we are going to have insurance. We are going to have a structure so that if the insurance isn't enough, and they've got to go after the insurance first, they've got to go after, that's going to all get exhausted, and then they might get a percentage of the company. And we have ways of getting them out of the company cheap. They won't be able to get the properties. Whereas if you had just a piece of property, and I own a piece of property, and somebody breaks their stupid neck by drinking too much, falling off the porch, and then blaming me because the porch was defective, again, they could get the property in that case. But by putting it in the company, we make it that much more difficult for them to get to it. Does a living trust get the same protection as an LP or an LLC? No. A living trust it's called by the IRS a disregarded entity, meaning it's like a purse or a wallet. You put your assets in the purse, you put your assets in the wallet. It can be reached by the creditors. Yes. Yeah, the question is, if you have 30 properties, can you create 30 LLCs so that if one LLC is lost, you don't lose the LLC? Yeah, you could, but at $800 a year minimum to pay the state of California, you're much better buying really good insurance in the LLC and organizing it as a single LLC. The question is, what about lawsuits that are not insured by insurance? Any lawsuit that has to do with liability on the property, landlord liability, will be covered by the landlord's insurance. Lawsuits between family members are not covered.
No, I don't mean that.
Well, actually, the comment is that some things like discrimination in real estate, you can't get insurance for. Actually, you can. And we might need a property casualty guy here. You can get landlord risk insurance that covers discrimination claims as long as and they'll cover that claim as long as the discrimination wasn't intentional. You can still get the lawyers paid for by your insurance policy. This strategy, the question is, would you use this for your personal residence? No. Would you use this for a second residence or an investment property? Yes. This is strictly a strategy for investment real estate.
A second, like just a single?
You could, if the idea was that you wanted to hold this for the next generations and you wanted to reduce fiduciary liability, the answer there is maybe. So create that limited partnership LLC, transfer the 50% to the decedent trust and 50% to the survivor's trust. All the beneficiaries are now sharing. The trustees now have reduced the fiduciary liability to ordinary business judgment, and we have a mechanism in place. If we've got kids who just want the money, they want to take the money and run, great, let them at a discount. So those who are able to hold on and stay the course and do what mom and dad or aunt and uncle built for them are going to benefit from that. Those who want to take the money and run, adios. We just got rid of the malcontents. In that situation, we had an AB trust where we had, the question is, do you have to have an AB trust? Not necessarily, but that was just this case study. They did have an AB trust, and we wanted to keep it in place. Ah. I did not pay this guy. But we now have the family farm. Okay. 3 children, 1 farmer. Jan and Dean, lifetime farmers with 3 children, Tom, Dick, and Harry. Do not bug me about my originality. I have none. But so these names are just coming out of a hat. The family farm is worth approximately $20 million. It has an assessed value for real property tax assessment of $5 million. But it's grown in value in the last lifetime. Only Tom wants to continue farming of the three boys. But he's concerned that if he has to sell off a portion of the farm, coupled to pay the estate tax, coupled with the real property tax reassessments, the farm's not going to be economical anymore. And it'll make it impossible for him to continue. Dick and Harry are sympathetic, but they want to make sure that they're treated fairly too. Hey, just because they're not farmers doesn't mean that they shouldn't get an inheritance. It shouldn't all go to Tom. So they want to make it's fair. Jan and Dean are 65 and have not done any estate planning. And here's what we've got in this estate. An estimated estate tax of $5.864 million. An estimated real property tax increase of $187,000 plus per year. And the potential of litigation between the brothers if they feel that they've been slighted, hokey smoke, priceless. Tim, there's a couple things going on here. This is where you're going to see some power going on because the attorney, the tax professional, and the financial professional are all going to weigh in. Scott, did you want to jump in? I mean, we got a problem here. There's no liquidity.
The very first bullet is absolutely the number one step you have to go through here. I mean, you've got to create that. You've got to figure out what it is you want to do, and you also have to understand what the 3 children want to do. And I come in on the second part, and in this case we have Tom, who wants to be able to continue the farm, and the other 2 children do not. So a couple slides back from here, we're going to walk through how we equalize among the children. But there is a way to create a leverage entity, and there are a lot, and we can go into it at another time because there's many different ways we can set it up. But you could actually, whether it's in investments, if you don't have an insurable, if you're not able to be insured, or there are many different kinds of ways to put insurance inside a trust that actually provides cash without the asset being sold to equalize to the 3 children. And Frank will walk that through on the next couple slides.
Yeah, watch what we're going to do here because we're going to try to save on estate tax, and we're going to save a significant amount on estate tax. We are definitely going to save on real property tax increases, and we're going to create some liquidity, some cash in this estate so that we can, if one of the boys wants out, we can get him out without having to sell the farmland. Here we go. This is the way we're going to save on real property taxes. This is kind of a mind blow for me, but it works. And my partner Jackie, who I introduced you to earlier, she has kind of a small sub practice just fighting with county tax assessors. Jackie doesn't lose. She wrestles them, she bites them, she kicks, she scratches, she claws, and then when all else fails, she wheedles and she whines and she pleads. But it really does work. Watch how I set it up, and she makes sure it works. We create this real estate limited partnership, and remember, what we're going to do is it starts that the parents own the entire farm. Then we create the limited partnership and we donate the farm to the limited partnership. To your point, we have a farmhouse and farm. The cool thing about that is that we can keep the farmhouse in the farm. That farmhouse actually counts as part of the limited partnership or part of the LLC. Because we had parents at 100% of land ownership, and we transfer it to an entity that has the same ownership, 100% by the parents, that's an exempt transfer for reassessing the property tax. Doesn't get reassessed. Then, what we do is we transfer 50%, the parents keep 50% of the limited partnership, the children receive 50%. As long as we don't click over 50% to the kids, doesn't count as a transfer for real property tax reassessment. Ooh, now get ready. We let 3 years marinate as a limited partnership. Why did we do that, Tim? Because Tim knows it. I'm going to kick it, throw it to you.
No, that's fine.
What we want to do is we want to give the IRS a chance to audit the gift tax return. And they typically don't. The audit rate on gift tax returns is around 2%. The audit rate on estate tax returns is around 100%. But after that, what we do is we go ahead and we dissolve the limited partnership so that the real estate is owned 50% by the parents, 50% by the kids. Remember what we set up here? As long as the percentage owner of the ownership of the real estate is the same as the LLC or the LP, there's no real property tax reassessment. The same over here. As long as it's 50-50 of the LLC when we transfer it back to owned real estate, and now it's 50%, 50%, the farm is owned 50-50, no real property tax reassessment. We have absolutely no limits on how much we can now transfer to the kids and not have the farm reappraised or reassessed for real property taxes. That means that $10 million of real estate, by doing it this way, $20 million of real estate becomes discounted to only $13 million at the LP level. We've now moved $10 million to the kids, taxed as if it was only $6.5 million. So the IRS is happy. We don't have a taxable event here. Now what have we done? We've gotten that $10 million of real estate to the kids, and that $10 million of real estate to the kids carries the old real property tax reassessment. Cool. So now what are we going to do? We're going to do it again. Only we're going to do it again just with the parents' half, just with the parents' $10 million. Why? So that we can put even more to the kids without being reassessed for real property tax purposes. Remember, each parent has $5.34 million that they can give away tax-free to the kids. And that's $10.68 million. And we've only used $6.5 million. So if we do it again with this $10 million, and it's now only $6.5 million, I can do 50% of that. That's going to be roughly, what, $3.2 million? We still haven't gone over the $10.34 million. We've moved 3/4 of the estate, $15 million of the estate, tax-free to the kids. And $15 million of the estate without being reassessed for real property tax purposes. Yes, sir? Could that be to the grandkids too? Could be to the grandkids. Except, no, hold on. For estate tax purposes, yes, it can go to the grandkids. But for real property tax purposes, no. Because as long as the parents are alive, we can only go parent to child. We cannot go to parent to grandchild for real property tax purposes. So the grandkids are going to have to bump off Tom, Dick, and Harry. So, small price. So that was our solution. Do that living trust. Do the family limited partnership or limited liability company. Exempt that reassessment. Knock off as much of the tax as possible. In the first go-round, we just knocked down the estate tax bill from $5.864 million to only $928,000 on that $20 million farm. Wow. Wow. And then we're going to do it again, because again, we're going to try to exempt the reassessment.
But then, Frank, you've got the Irrevocable Life Insurance Trust sitting there. And so what you do is you actually continue to reduce your estate through the gifting, and you put whatever type of policy that makes sense here into it, and we lost 2 kids at the very bottom. But Tom wants to keep the property. He wants to keep it whole. He wants to keep everything in there, and the other 2 children want to have cash. Well, the only way they're going to get cash is if Tom sells part of that farm. So what we do is further reduce the estate by gifting, put it into a life insurance policy. You might want to go to the next slide. And you create an irrevocable trust, which can have all the flexibility in the world to sit there and hold one asset, and that's the life insurance policy is going to equalize for the 2 children. If we don't make that second transaction, and we still have some estate expenses, that can also be used to pay it at that point in time. The property for Tom can be all kept in whole. It can all be passed on to him. He can continue to run the farm, and the other 2 children end up with cash, and they're probably pretty happy campers. And mom and dad don't pay the government the estate tax that would have been due if they did nothing.
So the question is, mom and dad really, let me rephrase that a little bit. Mom and dad really want to do something nice for the kids. They want to do the estate planning, but doggone it, they want the money to live on. They want the money for them while they're still alive. Can we do that? You want to pick that one up?
Absolutely. One of the beauties of an LLC or well, mostly the LLC or limited partnership is the fact that the ownership, the revenue or the net income can be allocated differently than the ownership of the entity itself. So mom and dad, that's part of the membership agreement within the LLC. They can retain however much of the net earnings from the property for their lifetime. This, in this example, Tom would earn a living for continuing to run the farm, etc. He would receive the home at no cost to live in, but mom and dad get the income stream for life, all allowable but within the LLC.
And that's a big difference between an LP, LLC, and a corporation, isn't it?
Absolutely. With an S corporation, which would be a pass-through entity as well, you can't have different percentages of revenue or the net earnings versus equity in the entity versus capital. They all have to be the one and the same.
Corey, to take it one step further, let's say, for instance, the income stream really dried up in the assets that you had available. And we have a slide in the next case that comes back to this, but I'll just go ahead and jump to it here. You don't have to change the slide, Frank. The trust can be designed so we call it a Spousal Lifetime Access Trust. So if during the lifetime grantor needs assets, he can actually invade the trust and use the cash value or whatever inside the trust. If once the death takes, and the spouse can be the beneficiary.
I honestly thought that attorneys had twisty minds and we could come up with all sorts of things until I met Scott. And there are ways that he can suggest to structure, finances and life insurance that, you'd think that the life insurance is really there for the kids. No, you can retain things for mom and dad.
Yeah, there can be a lifetime interest for, the grantor to come back in and invade that and use it. And if need be, because they don't have the assets to take care of their lifestyle. Yes? It can be one of both. It all depends if it goes over the $14,000 and we can borrow beneficiaries to be able to fund that. So we have multiple beneficiaries that can be used to design to take that $14,000 up to a fairly sizable number. If we do exceed it, then it gets into your lifetime exemption.
There's something called a crummy trust or a
Right.
crummy power on an islet. It's not a terrible trust. It's not crummy that way. It's actually named after an Episcopalian minister named Crummy,
Right.
who first did this in 1959, I think, and the case wasn't resolved until 1967 with the IRS. What he did is let's use the example, Tom, Dick, and Harry. Let's say that Tom had a spouse and 3 children. Dick had a spouse and 2 children, and Harry, single, no children. If you gave $14,000 a year to Tom, Dick, Harry, the 2 spouses, and the 5 children, that would be 10 people you could give to, $140,000 a year. But you can hear Harry going, "That's not fair. Tom's getting all that money because he's a bunny rabbit." A crummy trust says we can give that money to the trust, tell everybody you got that gift, and they've got 45 days to take their gift. If they don't take their gift in that 45 days, then it's called a lapsed gift. It goes into the trust, and the trust says that when that life insurance policy pays off, then it goes in 3 shares, Tom, Dick, and Harry. So we can actually use unequal gifting in the three families and still come up with that equal result.
It's just a mechanism to how you can fund it, and it's the beneficiary design at the end that brings it out in distribution.
Here's the cool thing about, and one thing you have to remember about life insurance. Life insurance, if you own a policy, if I own a policy of life insurance and it's got $1 million death benefit, that $1 million is included in my estate for estate tax purposes. But if we buy that life insurance with gifted money inside of life insurance trust, because it's money that's already been gifted outside of the estate, then that $1 million death benefit no longer counts for estate tax purposes. It already belongs to the kids.
Generally what we say, there's two stages of owning liquidity. One is to take care of your family if something unexpected happens, and the other stage is to provide more flexibility and liquidity after the fact when you're not there. And we can design, and so whatever the gifting is going to be, we're essentially reducing your estate and putting all that liquidity outside your estate to be used however you want it to be used to settle the estate and transfer the assets to the children. It all depends on what type of policy you're putting in and where you're buying it from. I mean, your advisor does have a fiduciary responsibility to design a policy. I wouldn't have a clue how much the premium is going to be. I can make the premium be very, very small, and if it's on a single life or on two lives, and I can make the premium to shorten the premium payments be very, very large, very, very large. If you're using the right type of life insurance policies, it doesn't come with one death benefit and one premium. You've got all the flexibility in the world to design it about what you're trying to accomplish in the trust.
And it is a matter of pricing. You do shop. You make sure that you're working with a true professional who's going to shop for you, who's going to make sure that they design the right policy for what your situation is, and that they're going to make sure that it really fits your situation, really fits your budget. And one of the cool things about working together, whoever your tax professional is, whoever your attorney is, whoever your financial professional is, making sure that they're talking together, because they're each going to have a perspective. There are times when we do these kinds of plans, and Tim has to say, whoa, we just don't have the cash flow to make an LLC or a limited partnership work. And we'll kick out. And sometimes Scott will say, this won't work because we just don't have the right options here. Or sometimes there have been many times when Scott has said, Frank, have you thought about this, this, and this? We can structure this a whole different way. And I kind of go, we can? I mean, he amazes me sometimes.
We may have a second to die with a first to die rider because one of the people, one of the mom or dad are very, very severely ill or have some complications. But, you know, some companies offer policies that do have a first to die rider, so we can create liquidity when one spouse passes away and the other may live 25 years. It's still sitting in the estate, but we've created liquidity to be used to possibly support the surviving spouse or pay expenses.
Question is this really restricted to fathers, sons, mothers, daughters, you know, parent to child? No. No, remember that example where we had Betty and Barney, and each of them had siblings. They had no children of their own. It was perfect in that situation. It was perfect to take care of the siblings or the nieces and nephews. So we can define who can be the eligible partners or the eligible limited liability company members, and we define it any way you want. Any way you want. So these are really, really flexible. Let's talk about toilets, tenants, and trash. You've done a great job saving. You've done a great job building up an estate, building up investment real estate. And I got to tell you, I come from a family, one of my earliest memories is sitting at my grandparents' dinner table because they were the kind of people who had the envelopes. Immigrants, they had the envelopes, paycheck would be cashed, and the cash would go in the envelopes. And one of the envelopes was for the rent, and the other envelope was for the grocery store, and another envelope was for PG&E, and then there was always the envelope that was for giving, because when we would go to church on Sunday, and then there was the envelope that was savings. And whenever the savings envelope got nice and fat, Paco and Nana went out and bought a 2-bedroom, 1-bathroom, nothing in Burbank, California. I mean, it was this little 850 square foot nothing. They did that. But at some point, they got to an age when they didn't want to deal with it anymore. It's tough being a landlord. and you get to the place where you say, that's it. I don't want to do this anymore. So how can they get rid of it? And let's say that the kids just don't even want to be involved in real estate. So we've got Rocky and Adrian, who've spent a lifetime building up a residential rental portfolio, now worth about $5 million. Their basis, what they bought it for and what they fixed it up with, is about $1.5 million. They're now both 65, and they're tired of the toilets, tenants, and trash. They'd like a reasonable income going forward to retirement, and they'd like to preserve some sort of inheritance for their kids. But honest to goodness, they want out. With a $12 million estate, they're also concerned about estate tax. They're over that $10.68 million. So their estimated estate tax here, if they hold on to all this real property until they die, and they have to pay estate tax, it's $528,000. But here's the killer. Remember that low basis in the real estate? If they sell to get out of it, the capital gains tax. They won't have an estate tax problem anymore because they'll pay it all in capital gains tax. $1,022,500 in capital gains tax if they sell during their lifetime. Having a tenant-free retirement, priceless. So what are they going to do? I'm going to throw it open to you guys because this gets fun. And oh, by the way, Tim, one of the cool things about this, Tim he has an expertise in charitable trusts, charitable foundations. He's on the board of several charities. I've had the joy of attending function at ARF with Tim. He's on their board. So this is, I think if you see his eyes light up, this is near and dear to his heart. Go for it.
Thank you. This, even though I love the clouds and the squares and so forth, this can become a little difficult or complicated to understand. But what's going on here is the proposal would be to shift the real estate into a charitable remainder trust, which is, the acronym is the CRUT, and that's donated to the trust. What happens is and I don't remember Rocky and Adrian, they would receive an income flow from that trust for the rest of their life with a minimum of 5% per year. And in this example, that represents $250,000 per year. They don't deal with the tenants any longer. Upon their ultimate passing, the real estate would go to the named charities, which is good stuff. When they donated the $5 million property, that's the fair market value, even though their cost basis was $1.5 million, depending on how old they are, what their life expectancy is, they would receive a 7-figure donation that would be tax deductible over many years. The balance of the $12 million estate, the $7 million, upon their passing or the first one's passing, would go into the AB trust. The B trust being the bypass, and then the A trust being the survivor's trust. And with the nice arrows going back and forth, the income out of the bypass trust would go to the surviving spouse. And then upon the ultimate passing of both of them, that $3.5 million or whatever it's grown to at that point in time would pass to their beneficiaries. What we spoke about in the last example was the Irrevocable Life Insurance Trust. Again, it can be funded on an annual basis. $5 million policy would be acquired, and upon the passing of the Rocky and Adrian, that $5 million would pass to their heirs. So even though they donated the $5 million worth of real estate that they built up over their lives, their children still inherit the $12 million.
And that's the cool thing. Notice that we've killed the capital gains tax, we've killed the estate tax, and we got an income tax deduction and still preserved the income for as long as both Rocky and Adrian are alive. And it's actually, if Rocky dies first, Adrian is going to keep that income. If Adrian dies first, Rocky keets the income. Scott, can you speak to the islet and how that works in this situation?
Yeah, can you go back to the slide a second?
Okay.
What happens a lot of times here, I mean, we're really moving the money over to the CRUT to get an income stream and also get the deductions. But the beneficiaries of the trust really are not, they're not happy. They're giving up $5 million in assets they were looking to inherit. Putting the irrevocable trust in there and gifting further reduces the estate, but comes back down to the original number for the beneficiaries that they were hoping to be able to inherit. You've got an income stream coming from the CRUT, but Frank, I think on this slide we haven't talked about it, but you've got principal coming out of the bypass. So you've got that set up for health, education, maintenance, and support. If the surviving spouse needs funds, the trustee of the bypass trust does have the ability to come in here and invade that for health, education, maintenance, support. There's another slide coming back, if you could for me. The Spousal Lifetime Access Trust.
Okay, I'm going to put that up there.
There. So what this is another little flavor. So let's focus on the surviving spouse who needs assets to be able to live, to maintain their lifestyle or take care of their care. This allows that the surviving spouse might be a beneficiary in the trust and able to invade that trust during her lifetime. So now you've got two mechanisms available for that surviving spouse for health, education, maintenance, and support. You can invade the bypass trust and use the principal if need be by the trustee, or you can have the original trust set up holding the life insurance that if they need funds, they can also come back and use this. So you've got, in this kind of strategy, you've got flexibility not only for the surviving spouse, but now you've assured that the beneficiaries are going to get the full amount before mom and dad did any planning. And the gifting going to the trust just reduced your estate. So you're shifting it essentially out of the estate to your kids, and it flows all the way through. That was a lot. Any questions?
Right now I'm starting to see heads spin going, wow, you can do that? Yes. Is this at all pushing the envelope? No.
No.
These charitable remainder trusts have been on the books since, I think, 1962. And if you read the congressional record, you see words like, we know we like schools, we know we like churches, we know we like hospitals and museums and parks and all this other stuff, but we simply don't have enough money to fund everything. So if the American taxpayer is willing to do something good, create a charitable remainder trust, we will give you tax breaks like you cannot believe. Will these tax breaks ever go away? This is where I'm probably going to argue. You know, Tim was very pessimistic about what would happen to the exemption equivalent. Would the tax-free amount go down? Okay, that tax-free amount could go down. We could lose the $5.34 million. We could go to $1 million, which is where the permanent tax law was supposed to be. But will the charitable remainder trust go away? No, because every charity in this country, every church, Animal Rights Foundation, Children's Hospital, every charity depends on these for giving. So if Congress ever tried to monkey with this that's been on the books since 1962, you would see a march of every charity I can imagine marching down on Washington saying, heck no, you can't do that. So,
Frank, if I can come in here.
Please.
I'm not the attorney. I'm the planning guy who comes in and works with the other advisors. But I would say 95% of the trusts that I read, and I read them all before, but either before or during when the attorneys are involved, they're vanilla. They weren't created by sitting down with the attorney, a planner, to the tax preparer, the tax planner, not preparer, and really looking at the end result you're trying to achieve. They read like they came off the same word processor. You can design these trusts. You can design this to do exactly what it is you want to do. How did we take care of Tom so he could manage the farm and his siblings got cash? A plain vanilla trust isn't going to come up that way. It takes someone who understands what they're doing to draft documents. They're going to give you the flexibility, which is the key in everything you're doing, having that flexibility so you're able to achieve what you want to have, what you've built the assets. What do you want to have those assets do when you're no longer here?
Okay, points to remember. We're doing a lot of playing here with the estate tax. We want to kill the estate tax. We're not so worried about capital gains tax with real estate. Why? The estate tax is due and payable within 9 months of date of death. Capital gains tax never needs to be paid as long as we use Section 1031 and do 1031 exchanges. That's the whole point with using a family limited partnership or LLC. We can defer that tax indefinitely. Liquidity, I mean, lots and lots of ways that Scott's given you today. There's no need to pay estate tax as long as you give your team enough time to plan. And honest to goodness, planned and executed well, we can reduce real property taxes to next to nothing or even nothing. Excuse me, we can reduce the reassessment to next to nothing. And I learned it from my grandparents. I saw them do it. I saw my parents do it. God willing, my kids are seeing me and my wife do it. Real estate continues to be one of the best investments in California, and I don't see that changing at all.
And Frank, one last caveat there. If you really want to pass it on to your children and you don't want to have your children bickering among themselves, there's many ways to do it.
And we've given you really 3 important ideas here today. We've talked about limited liability companies, limited partnerships. We've talked about liquidity planning. We've talked about charitable trusts. 3 different approaches to taking care of real estate wealth and preserving real estate wealth for successive generations. The important thing is, this is Scott's slide. We're going to throw it open for questions. So does anybody have any questions here? Or any final observations, gentlemen? So questions, comments, moans, groans, gripes, and complaints. Now's your chance.
Frank, if they don't have a question now and they think about it as they're driving home down the freeway in 680, why don't you grab our brochures and so forth? You might want to take that home and look at it, and if it, a couple weeks from now it comes up, please feel free to give us a call.
And I work on a system that says that I don't charge for email time. So please, if you have questions, shoot me an email, ask the question. I'm happy to answer.
Frank, I think we have a question back here.
We have a question. Yes, sir. Okay, let me restate. The question is really, I'm going to kind of make it a little bit more general. The question is, if you have an heir, a beneficiary, a loved one who has a special need where they're going to need SSI or Medi-Cal, how do you structure an inheritance so that it keeps those benefits in place and so the state can't get a reimbursement? You desperately need to revise your estate plan to include what is called a special needs trust. A special needs trust is where your kid doesn't get it outright, your loved one doesn't get it outright. It's held in trust, and it's held in a trust where, because it's not their property, it's the trust's property, it does not blow their SSI, it does not blow their Medi-Cal, and it cannot be subject to reimbursement after they pass away. And after they pass away, this may be a nephew, but you can say after he's gone, after we've taken care of him for the rest of his life and he's secure and he has a house of his own and he doesn't have to worry about living on the streets, okay, then that house can be given to my kids after he passes away. But that's the way that you do it. And really, for special needs planning, we really want to do that because it's a passion of ours to make sure that children or adults are taken care of.
Okay, my last question, which one of you 3 would I want to see?
On special needs planning, that's probably me. We've had the blessing, by the way, we do a lot of special needs planning. Jackie, Tracy, and I. Tracy does a lot of the conservatorship work that's part of it. And we've had the blessing of doing it well enough that the United States Air Force called us 5 years ago and brought us on base at Travis Air Force Base to do this kind of planning for all the airmen and all the airwomen who are attached to that base, so who have special needs kids. It's really been an incredible time. Yes, sir. Can a living trust incorporate the parent and child and the assets of each? No. No. Remember, what we're doing is we're talking about the taxable estates of the parent and the taxable estate of the child. And so each should have their own living trust. When they do have real estate, for example, let's say that a parent has an apartment building and a child has a fourplex, can we incorporate those together in a limited partnership or an LLC? Yes. Yes, and that's really a very, very, very powerful way to create an LLC is when multiple family members all have investment real estate. I'm coming around this way. Yes, sir.
Tom, Dick, and Harry.
Question is, you've got Tom, Dick, and Harry who are all part of the limited partnership or LLC. One wants out, the other two want to hold on. How do you keep it from being reassessed? You make sure that you don't transfer more than 50%. So 1/3 is not 50%. We should be home free there. Correct. It has to be in an LLC because if Tom, Dick, and Harry own that real estate together, that sale is going to show up on title. That is going to be, it's not within the structure. It's out there in title, which means the county tax assessor is going to be sticking out their hand and saying, oh, that's a brother-to-brother transaction. Okay. Yes, sir. question is, how do you do all this valuation and what happens? What happens when you create an LP or an LLC is that you will have appraisers, and with properties that have oil and gas reserves or farmland, we use specialized appraisers who really know that world to do the appraisal. Once you've had all the property appraised, then you have a business valuator value the business, including all those discounts. So it's a two-step process. Okay, we're going to stay around. Oh, one last question. The question is, how much does this all cost? What we typically do is we have a consultation. We sit around a table together. I count the number of arms and legs around the table, and I take one of each. Honestly, can we take all three from one person? Ooh. Now this, have you ever thought about law school? We really can't tell you until we actually sit down in consultation. Our goal in the consultation, one of the reasons why we do have a free consultation, is simply to get to know you better and find out exactly what we're talking about. Once we know what we're talking about, sometimes with larger, more complex estates, with a farm estate, for example, I just finished one where I did the proposal. We have the consultation, and then it took me about 4 to 6 hours on a Saturday to put together a plan and make a presentation, say, this is what I think you need, and this is what you're going to have to do. I will tell you, limited partnership and LLC planning, when you're doing valuation discounting, more expensive because of all the appraisals and valuations and the time that go into that. A living trust, very, very, very inexpensive. ILETs, very inexpensive from the attorney's point of view. But we have to get to know you better so that we know what we're doing.
On my side, we've got a little chart in here of our 6-step process. We're probably going to be through step 2 before I even know whether or not you want to do business with me or vice versa, or if I can help you. And until we get past that point in time, I wouldn't have a clue of what fees might be. Because from my perspective, it doesn't make sense to go forward if there's nothing there that I can help you with.
And that's really kind of the way I think all three of us work. If we can't help you, we'll tell you. And I don't know, in our shop we take a lot of pride in simply being able to say, this is what you need, and not selling you on something you really don't need.